in our industry. Quite often, instead of using other copyrighted material, we are more likely to use data owned by somebody else, right? So if I want to dump my entire database of all of our locations and everything over to Keith's model, and he learns how to do things better, it would be possible for me to share data that some of our customers would consider their owned data, right? So it's not copyrighted, but
Well, now
there
you're
is
going
a
into
right to it by contract, right? That they said, look, we want to own this data. How does that compare or play into these scenarios?
So what you're kind of jumping into the field of data privacy a little bit, and I'm going to say, because of where AI is currently, a lot of the protections that are surrounding people are not from IP law, which is a little bit slow to catch up. They are from data privacy and contractual obligations and licensing, all of that out there. You may have read the case against, what was it, Microsoft and I'm trying to GitHub. Yes. They didn't mention copyright basically at all. I mean, they mentioned the Digital Millennium Copyright Act, but mostly they mentioned contracts and data specifically. So in the case where you're wondering, how does this apply to me? It's almost important to take an inventory of exactly where you're using it in your business, where you anticipate to use it in your business, and then create some sort of web of other patchworks of laws to protect yourself. And you have to be a little bit creative about it.
Yeah, and Pete put a comment in here just to, it is a little bit different than, we're not spitting back clips or pieces of other people's work in this case. I would akin what I just mentioned closer to, I went to college, I read a whole bunch of books that were all copyrighted and so forth, and it taught me how to think and be an engineer. We're doing the same thing with data, with AI, where we're teaching it how to think originally and better and so forth, using data that's out there. Some of which might be, if it's privately, what was the term you used, Kat? The data privacy. If it's covered under a contract for data privacy, and somebody utilizes that could be an issue, I think, by the sounds of it.
Yeah.
Is data, sorry, just on that one, Kat, if and Mark brought this up, I think last week, if I publish it, for example, if I publish an article on, some technology in our particular space, and I don't mark it for data privacy, or I don't mark it for copyright or anything like that. Well, let's go the other way. If I do mark it for like copyright, and then, ChatGPT picks it up and transcribes half of my article without acknowledging the copyright, is that an exposure on ChatGPT or on me, or where does that fall?
So if you're saying that you have protected your article using copyright law, right? And someone uses it, reproduces it, or makes a derivative work of that without your consent, yes, that's copyright infringement.
Okay, right. Regardless of whether it's an engine or a person or a computer or whatever that did that work.
Is that any different from Shutterstock pictures and stuff like that in PowerPoint presentations and things?
If someone has a drone that fires on my house, I'm going to sue the person who owned that drone.
Yeah. Yeah.
The difference, I'm sorry. The difference, the critical difference, Anna, is in scenario one, ChatGPT picks up your article and learns from it and produces something that's completely different. In scenario two, ChatGPT picks up your article and produces basically your article with your words. Scenario two is clearly an infringement, but subject to maybe some other defenses. But scenario one is the place where the rubber hits the road, because that's raises a pretty strong fair use defense. And I would also say on the contract issue, I think those are going to be really, really tricky, because contracts can say anything they want. You can have a contract that says, you cannot use my data to train an AI. You can have a contract that says you can use my data to train an AI, but you can never share that AI with anyone else or use it with another customer. It's really kind of anything goes. And I don't think the courts have recognized, like in copyright, it's all one big system of laws. So you have copyrights and they're limited by fair use. And that's why we can talk about enabling this technology by excusing copyright infringement. Contract is not like that. There's no big defense that you can point to say, sure, I agreed in this contract not to use your data to train an AI model, but like, no, if you agreed in the contract, that's what you have to stick to. So it's a little different in that respect.
So Luke and Kat, so Luke, back to your example about ChatGPT. So what if ChatGPT creates an article? Let's say it does a profile of me as an example. And I find it and it is completely incorrect. It's false. Information on it is not there, whatever. What ramifications do I have to get that stopped? Or legally, Kat, Luke, do I have any ramifications? Other than good luck, Mark. Yeah, thank you. And,
Are your pockets deeper than Microsoft?
oh, and, and last night, 60 Minutes actually did a piece on somebody who had a online newsletter and did not write some favorable things about eBay. And if you saw it, if not, go to 60 Minutes. It's interesting what, in this case, eBay took the actions that they tried to take, of which many were illegal anyway, but that's beside the point.
Do you see a use case in our industry around that, Mark? Or is there something specific you're kind of
Yeah,
poking
I
at?
do. In that, again, I've seen our industry, like many of us on the call, we've been in this industry for years and years. And like anything that's published out there, as a content creator, we all try to be accurate. All right. Occasionally we can make mistakes, but there's blatant stuff that's out there, especially in our industry, that is false, that is incorrect, that is whatever. And again, here you have AI creating this. I don't have Tracy, so I can go after you, Tracy, if this is incorrect. I got something out there, I got nothing to do here, I have no ramification as I see it.
So somebody writes, or one of these tools generates negative reviews, let's say, of a product that one of us manufacture, for instance, or something about our companies or whatever. What are our rights?
Right.
Surrounding that?
Luke, I've got some thoughts on this, but you're
Oh,
also
please.
free to chime in.
No,
Okay,
please.
so in this scenario, what I see a lot of times when there's any sort of new and emerging technology is that clients come to me and they ask, what if this new technology does this old crime? And it's, you apply the old law to the new crime as best as you can, because again, law is trying its very best to catch up. So if someone, be it AI or be it someone on the internet, publishes libelous statements about me, I'm going to go to libel law. I'm going to go to slander law. I'm going to pursue the avenues that are already created and see how they apply to me, as opposed to creating some new claim based on AI specifically.
That makes sense.
Keith, just in sort of circling back to your application, because I kind of put all this into two camps as well, right? So for me, ChatGPT, if you kind of go to the core of the technology of ChatGPT, it's a transformative, it's a predictive transformative engine. What it does is it just looks to put together the next word that makes sense in the sentence of all things that are out there. So it doesn't actually create something new per se. It just goes and says, okay, in this context and this application, and I scour all the material, this is the next logical word that has the highest rating on. in your world, though, you are more in the machine learning space, right? If I understand that correctly, where you take data, let's say temperature data, you take temperature data from 1,000 sites for argument's sakes, and then you train your engine, which itself then does something different to somebody else's site, right? And I kind of separate that as back to my AI versus machine learning.
Yeah, that's a great point, Anno. I mean, so we really want to make sure that we understand the difference between what's called, artificial general intelligence or AGI. So that's what more people, scientists, data scientists, other people are not quick to call Chat GPT like general AI, like the holy grail of AI, where it's completely it's sentient almost, right?
Sure.
What we're doing is application specific. Like it's got guardrails. It's never going to figure out how to write a poem or draw a picture. It just runs buildings better. Like it's like an augmented PID loop. Like I'm telling you, that's the difference. So there's a lot of stuff going on, because what ChatGPT has done is it's brought a huge awareness of the impact of AI. Right. But it's like apples and oranges compared to what we're doing versus ChatGPT. It's nothing like it. Like what data are we consuming? Data that we're gathering. What data are we changing? Data that we're gathering. So it's our data. It's localized to the customer. It's customer specific. We're not using one retailer's data model to drive another retailer. Yet. But maybe we might see some benchmarking type things, best practices. But no, it's specific to this application, and that's just making a PID loop run better.
Although
So
I
a
have
couple, I don't know if I could.
Yes,
Yeah. So a couple things. For Kat's benefit, a PID loop is a control algorithm.
I'm sorry.
Thanks, Steve.
So, but the bigger thing I want to do on your point, Keith, tying to what Jim mentioned earlier, the fact that with the technology of ChatGPT, you can go in, you can scour the internet for anything and everything. Okay, I'm interested in the liability that could potentially impact us as manufacturers. So if I advertise that my product is able to go out and gather all this information and then use that to better operate your building. What you mentioned earlier, going back 20, 30 years ago, because you had control over everything and you qualified it and tested it before you released the product, you had quality control mechanisms in place. If I go out and just grab information and let it determine the outcome of how I'm going to run a building without having quality control checks in place where I validate that the information I just got was really something that isn't going to harm my solution, am I then reliable? Am I then responsible, or can I be held liable for damage that could then result from the use of my product?
So maybe going a little bit too far, but I don't mind. But you just described like a well-funded big competitor of ours. So the difference is between, we're controls guys. We understand how this stuff works. So we're definitely not. In fact, that scenario was actually promoted to an existing customer of ours by a competitor. How are you going to run my central plant? Well, we're just going to turn it loose on your multi-million-dollar chillers, and it's just going to try a bunch of different stuff and figure out. It's like, get out. Like no.
Yeah, exactly. That's the liability issue to me is critical. It's critical.
And our competitors. Like we're not only experts at AI, and this is not my first AI company. I did something with CSI work, police, law enforcement, but we're also controls gurus. So that Steve is the difference, and you should be liable just if you were the same as if you were a commissioning agent and you came in and retro commissioned stuff and you didn't know what you were doing, and you allowed a heat exchanger to freeze up and expand and break or something like that.
Right.
Or you blew some duct work out. So it's
okay. So let's give Kat and Luke a chance to weigh in on this, because I think this is a really important issue.
This reminds me of, this is just, we're talking about torts here. We're talking about negligence.
Yes.
And this is essentially the same question that People have been asking that area for 100 years, and it's an area of law that started with cars, actually. You know,
Yes.
people started making cars, they weren't sure what's going to happen, they didn't do certain safety checks. And as a result of that, the courts developed a very robust law of negligence that has this really amazing formula that I love to think about. It's called BPL, which is, you know, the court theoretically is going to think, okay, what is the cost? So say you did not implement airbags or some protective measure. What is the cost to you, manufacturer, of implementing that measure? And we're going to compare that cost to the probability of something bad happening times the amount of loss that occurs if the bad thing does happen. It's a very, very simple idea, but it's
Yeah, the Ford Pinto comes to mind with that.
yeah, exactly right.
So Luke and Kat, all right, so to your, again, nice example, Luke. Question then is, artificial intelligence is not human. Humans can cause problems or what issues, and we know how to deal with that. So what are we saying about AI? Is it
But-
human? No, it's not human. So how would a scenario that clearly was pointed at AI was found to be the cause, the root cause? How does one obtain liability? You know, what would y'all say about that with respect to liability? Because again, it's not human. It's not an individual.
It's so I would say that AIs are not human in the same way that like a car is not human. It's a machine that's made to do something by humans. And as Keith said, they're not sentient yet. Maybe when they're sentient and they are going out doing their own stuff and acting in a way that's indistinguishable from humans, then we can talk about whether AI should have bank accounts or should own companies and should be held liable as persons under the law. But right now, they're extremely sophisticated and they're very black boxy, and we don't really know what's going on inside of them. But ultimately, there is someone who's responsible for designing a system, whether that's OpenAI for designing like a general AI model, or a company that downloads the model and tweaks it to a particular need. There's going to be some human being or company that is responsible for designing the system. And in the event of liability, that liability will be traced back to the people who are responsible for the system. In the same way that when you have a car crash 100 years ago, you had to trace liability back either to the car manufacturer or the person who made the tire or the person who made the rubber who was in the tire.
You say the same thing concerning open source? A lot of AI
Mark, could you let Kat just comment on your previous question?
Both of them.
Yeah.
Yeah, absolutely. So agree 100% with Luke. Love the negligence example. And I'm also going to say, in a scenario that I see growing worldwide, is that people are looking to AI solutions providers and are contracting with them. And in that sense, liability may be traced back to whoever drew the short end of the straw, whoever wasn't paying attention to their risk allocation provisions. So it's something to consider as well.
Am I thinking about this right, listening to you two, that this is no different than a tool, right? If I'm using a tool to do a job and the tool doesn't do it right, it's still my fault because I'm the one who chose that tool, who employed that tool, who used it to do whatever I'm doing. I mean, that's kind of how I've been thinking about AI in our industry.
Remember ProTuner? Like that's a tool where we used to use to tune up. I've seen people blow up boilers, all kind of stuff using ProTuner. But same, seriously, you know, I've seen all kind of stuff out there. I'm sure you folks have too. I mean, negligent people who are negligent. It always goes back to the person, not the tool.
Mm-hmm.
I think everyone would benefit from, like, I like the term artificial intelligence because it makes me think of like Isaac Asimov and Arthur C. Clarke and stuff like that. But when analyzing these kinds of issues, I think it would be better not to use the term really and just to talk about machine learning or whatever it is, because you're right, it is a tool. And from in all relevant respects, I believe at this point, it's the same legally than other tools. We just have to, it's just a little more complicated to analyze. Sorry, Kat, you're gonna say something.
Oh no, I was appreciating your mention of Isaac Asimov.
I was gonna say, she's a fan, I can tell.
Yeah.
But it kind of makes sense because if you know you sat an exam and you use ChatGPT to actually write your answer beforehand, you know, you actually implemented it and deployed it. They just gave you the answer, so it's down to you as an individual about the deploying and implementation of everything we do with that information.
That's right.
Can I ask a general question? If we were to look at the law, and obviously they're going to be titans, the big companies that are preparing this technology, small companies, many companies hashing this out. What's the time constant before this settles out into understood law?
Do you want to give an estimate, Luke?
There's a chance well, let me give you an example, like the fair use issue that I was referring to earlier. There are cases right now where this has come up, and those cases will either settle or get litigated, but it's very likely that in the next 5 years, we'll start to have some court decisions about whether training an AI on content, copyrighted content, is fair use. So we'll probably get some guidance there. It might not be authoritative because there's levels of appeals and courts can disagree with each other. But we're probably going to start to see some guidance on that question soon. The more difficult example is like there are some questions in this area that don't lend themselves to easy answers and probably will be, as Kat mentioned, a completely case-by-case analysis. Like the question whether a user owns an output of an AI model after typing a text prompt. I mean, the Copyright Office has said you need to demonstrate creativity if you want to say that you own the output. But those questions are really difficult to answer. Like, I could give a computer an extremely detailed text prompt that specifically dictates a result, and what it spits out, I can probably say is something that I wrote because I literally dictated every element of it. But at the same time, I could give a computer a text prompt that's super vague, and I won't be able to claim ownership of the result because I'm not responsible enough for the content. Drawing a line between those two things is a very, very difficult enterprise for the courts. And that, I think, will probably take many, many years to develop the doctrines that you use to answer that question.
And I'll address it as well, just from a little bit of a different angle. You've probably seen, Luke, the Draft AI Act that's been issued in Europe, and it, nothing is solid yet. It is just the precursor, but I remember having a small heart attack when I went to my first conference that referenced GDPR. And I had my tiny heart attack because I knew how much it was going to impact the legal landscape and put everyone into a tailspin for the next 4 to 5 years. I see something very similar happening with AI because if Europe is addressing it, like Ken mentioned, your industry is very global. And so something that affects Europe is, well, maybe California will again be the trendsetter in the United States, but I don't see it going away. And they make specific reference to intellectual property as well as advertising regulations, which seem to take a little bit from FTC guidance on dark patterns, which is another of my niche interests. Be happy to talk about it another time. But yeah, things are coming. Things are coming, and next 5 to 10 years, there's going to be disruptions.
We're right at the 3 o'clock, Keith, but go on for the one last question if you
Okay,
like.
yeah, and it's a shame with Kat and Luke being here, but what I'm more concerned about than the IP stuff is, and maybe it's along those lines, is I'm afraid. I wouldn't use the word term afraid, but I'm concerned about the big blue and red gorillas in the room suing me because I'm taking market share from them because they haven't innovated. Like what, so what about the patent lawsuit stuff that like, and I wish we had jumped on that earlier, but I mean, any last words about that? Because that concerns me much more than the trademark copyright stuff.
And for Kat and Luke's perspective, what he refers to the big and red and blue are the big two competitors in our space that we
Oh,
will
sure.
refer unnamed.
Yeah.
Fair enough. I will say I do not dabble in patent law. You're required to have a scientific degree in some version to practice. I know enough to get me in trouble, so I'm not going to lead you down the wrong path there.
Luke, any thoughts along those lines?
So I can't give you a lot of advice on this front, other than to say that this is no different than any other commercial context. There's nothing about the fact that you're doing machine learning that makes it any different, other than maybe it affects the universe of prior art that you look at, or the validity of certain patents, defenses. You know, it's the same as any patent dispute.
Okay.
So it's that's not a very helpful answer to you, I know, Keith, but I would approach it the same way as you guys. You guys must have run into these issues.
Oh, yeah, yeah. I've worked with David Bailey before on this type of stuff. So, yeah. But I was just asking because it doesn't even have to be a legitimate claim, if you know.
Right. Yeah, that's just tie you up. I'll leave you guys. I really appreciate Kat and Keith and Luke's time today. I think your input has been fascinating from my perspective. I've learned a lot. I'll leave you with one anecdote that I've got that ties temperature sensors and lawyers together. So years ago, we did a demand response project. We deployed a bunch of data acquisition, and one of the tenants in the building were in fact lawyers, and they asked us what we were doing, and we showed them the graphs of the temperatures and the pressure and the utility rates. And they said, yes, you're not allowed to do that. You should stop doing that.
Net lease, yep, I'm paying for that.
Well, we asked them why, and they said, well, it's possible that one of our customers might subpoena your temperature data to indicate whether we were in the office or not in the office,
Oh,
and we sent a bill. Fair enough, we stopped.
right. Well, thank you. Really appreciate it. Thanks for having me on.
Thanks,
Yeah,
everyone.
thanks very much.
For having us, guys.
Thanks.
Kat,
Great, thanks, guys.
thank you so
Thank
much.
you very much. Thank